Hi, I'm Cecilie Soendergaard Nielsen, and I'm the founder and managing director of leadership consultancy and coaching practice CN8, where I work with C-suite and board level leaders across energy, tech, and finance. Before setting up this business, I had a career as a global HR director, which is how I originally came across Emma Sangeelee. Emma's a partner and employment and discrimination specialist at law firm Edwin Coe, and she's been an invaluable support both to me and to a lot of people I know throughout our careers. That's why I'm so excited to have this opportunity to talk to Emma about a topic that doesn't usually get a lot of airtime: discrimination. And perhaps, Emma, can you introduce yourself and tell us why this is important and why it's better for all of us to have these conversations openly?
Thanks, Cecilia, and thanks for having me. So as Cecilia said, I'm a partner at Edwin Coe. I'm an employment lawyer and discrimination specialist, and I act for employers and employees, but I have a particular focus on acting for senior executives in high profile and complex discrimination claims. In terms of why it's important to have this discussion, I think we've had the Me Too movement, the Black Lives Matter movement, and people are becoming increasingly aware of unconscious bias and the fact that discrimination is something which does not have to be overt, it does not have to be deliberate, and it's something which affects us all in all areas of life and obviously in the workplace. But I think the challenge which comes from that is knowing how to identify whether you're being discriminated against, and then how best to articulate it. We're not used to doing that. We've come from a put up and shut up culture. And so part of what I'm trying to do, and Cecilia, I know you're passionate about this as well, is sort of a call to arms and also an offer of support to individuals to help them do that, to identify what is and isn't discrimination and how they can raise those issues with their employer to get an early resolution.
And that's key, isn't it? It's the opportunity to actually have the conversation and do something about it and maybe get to an early resolution instead of shoving it under the rug and hoping it goes away, which usually makes things so much worse.
Yeah.
But you mentioned knowing whether it's actually happening or not. How do you know whether you're being discriminated against or not? Because I think a lot of people just don't.
Yeah, I think that's right. At the outset, often you don't know, and I think it can start with a feeling, and it's a feeling more than just of unfairness. I think where there's, where you've been discriminated against, it's not reasonable. There's not a rationale for it, and that can lead to a feeling of disempowerment. So I would say, you won't always know, but you should trust your instincts to dig a little deeper. And the law is on your side. It offers you a roadmap to first of all identify, might you be being discriminated against? It also shows you how you need to structure your arguments so that you can effectively raise those points with your employer. So it might be helpful just to give an overview of what the law in this area looks like. I mean, it's complex, but I'll just give a sort of whistle-stop tour. So there are three main types of discrimination in relation to what's called a protected characteristics, which are things like age, race, gender, religious belief, sexual orientation, those sorts of things, disability. And so you have direct discrimination, which is, we're paying you less because you're female. You have indirect discrimination, which is where an employer treats everyone the same, but in doing that, there's a disparate impact on a group of a particular protected characteristic. So an example of that might be they won't allow flexible working. Yeah. And you might say that has a disparate impact on women because they share the burden of childcare responsibilities. Which
really ties into the whole kind of equity piece of diversity, equity, and inclusion, doesn't it?
Yeah, absolutely. And the other one is harassment, which it tends to be more overt, so nasty comments and things like that are linked to a protected characteristic. So they're the sort of three main types of discrimination. There are others specific to disability, and we'll come on to talk about victimization. Okay. But to sort of break that down, the first thing is to think, am I being treated differently? You need to have this difference in treatment. So, if you've got a boss who's just nasty and a bully to everyone, that's unlikely to be discrimination because everyone's been treated badly but the same. And then the next thing is, what's the reason for that difference in treatment? And you do have to tie it to a protected characteristic. So again, if it's just personality clash, or there's some other reason that's not related to a protected characteristic, then you're not going to have that discrimination claim. So if you think, I don't know, your boss is older than you and you're young, and you want to say it's an age discrimination claim, but other comparators are the same age as you and they've been treated differently, that so it's about sort of doing that assessment in the first instance. And then the next thing is there a causal link? So you've got to make a link between what you're saying is wrong and that protected characteristic. And that tends to be the big battleground, because you, of course, will say, well, yes, there is. And the employer then will defend that. And usually they'll defend it by giving, they'll have to give some reason not related to discrimination. And often that can be, well, you'd hope it was something neutral, but unfortunately, often it can be you perform poorly, or, things like that. Yeah. So that's where the battleground often lies. But that sort of analysis helps you then identify what things you want to raise and what things aren't worth raising, and really focus it so that your employer sort of can grapple with sort of certain complaints, but also not be distracted by ones which could undermine actually good points you've got to make.
Yeah. So, okay. So if you have this kind of instinct or this feeling, the questions to ask yourself are, am I being treated differently? Why might I be treated differently? And what's the causal link?
Yeah. Yeah.
Okay.
That's the first step. And then the next step is to think, well, what evidence is there? What can, you can say it, but I think realistically, well, there are 2 points. One is that whoever is addressing this concern is unlikely to be the discriminator themselves. So they're going to come to this without really knowing the facts. And that's, of course, the case with a tribunal. So, you have to consider what evidence there is, or what evidence can I compile. And it's a very common concern that clients have. It's one of the most common concerns. They say, I think I'm being discriminated against, but I can't prove it. And so really sort of applying your mind to that, I think, at an early stage is important, because it goes without saying that if you're able to raise your grievance showing evidence to support what you're saying, you're much more likely to get an early resolution than if you're not.
Makes sense, right? And I guess a lot of people, when they have this initial thought, they don't necessarily take action. You wait and wait until it gets so bad, and then you've missed an opportunity. So what kind of evidence should you be looking for in this instance?
Well, I guess so. To start off with, there's just the direct factual evidence. So obviously it will depend on what your claim is, but we're looking at emails, WhatsApps, meeting notes, diary entries, all those sorts of things.
Diary.
Yeah, I mean, everything, I guess, as a lawyer and a litigator, I deal with things where they go wrong and when there's a dispute. And I suppose one of the things for today is to try and encourage people to think a bit more that way, which is counterintuitive, of course, because you want to give people the benefit of the doubt. But I think, you've got to anticipate that usually there'll be some pushback. And what's that likely to be? So it might be, if you say, my boss told me this on whatever date, they might deny it. So what evidence do you have to support that happened? And again, if the likely response is going to be, well, you were paid less because you didn't perform as well, or you got a lower bonus because you haven't been acting for as valuable clients, whatever the rationale might be, you can put together a bundle of evidence that supports what you say. So it could be words of praise that you've received from your manager. Often you have these sort of great job, all of that stuff adds together to paint a compelling picture, where after the event, if you raise your concerns, your manager suddenly says, oh no, I've always had concerns with your performance. That can jar with those sorts of chats. And I mean, WhatsApp is a good one now, because, you know, people are less formal over WhatsApp, and they don't always realize, in the same way as with email, and certainly written documents, that these are disclosable. You know, you can rely on it. It doesn't have to be a sort of formal document for it to be valuable evidence. And so I would really encourage individuals to start to think this way a bit. So, you know, if you're having a conversation about anything that really matters to you in terms of, you know, whatever it is, pay, promotion, client allocation, whatever it is, try and record it in writing. And that doesn't have to be a blunt tool. It can be as simple as a WhatsApp message. It could even be, I mean, you know, obviously if it's direct with the discriminator, and, you know, that might be the best evidence, but it could even be a message to a friend recording what was said at the time. It's about having a contemporaneous record, which will help in the event that there's a dispute on the factual evidence, which, you know, there often is. Yeah,
I guess, you know, it's very human and natural to get defensive if you're accused of something, and your instinct will be to try and kind of get it to go away, right? And and then it can escalate into a conflict where it didn't have to be one. And I guess the other thing I'm thinking is there's nothing to lose, is there, by collecting evidence, because if you don't need to use it, then that's great. But in, you know, in the event that you do have it, and otherwise you can just get rid of it. But so what you're saying is actually, you know, diary entries, if you're seeing, you know, a coach or a therapist, even if you brought it up with them, it'll be in their notes. WhatsApp,
absolutely,
like anything that
absolutely might, really, really helpful. And like you say, it you know, it's one of those things, it does require a bit of effort to sort of, but it's not only mentally to sort of set up a file where you just drag and drop all of this stuff or keep records, because we're not used to doing it. But you will thank yourself for it 1,000 times over, if you do, because you'll have all of that ready. And I mean, the reality is, human memory is fallible, and at the time you think, well, I'm never going to forget this meeting. But, you know, go forward 6 months to a year, and you do, and then it's really hard to sort of trail through emails, or, you know, to try and find the evidence. So it's a really good idea. The other sort of evidence is indirect evidence. So there are sort of things that tribunals can draw inferences from. So, for example, if you are raising a complaint about discretionary decision making, and that, you know, men get paid higher bonuses, for example, you can look at, I mean, again, this is not going to, the whole case isn't going to turn on this, but looking at sort of indirect evidence, like, I mean, I'll give an example of an organization where, you know, the board is all white men, the administrative staff are all women, and it's sort of a structure like this, you know, where you get fewer women as you go up. That there are inferences which go along with that. You know, it's reflective of a culture. You know, social events where, you know, there used to be that sort of boys club, strip club culture, but, you know, you get varying degrees of that banter that's inappropriate. You might not want to bring claims about those things, but it's all relevant context, particularly where you're looking at unconscious bias and discretionary decision making, which is where a lot of this shows up. So yeah, that's another aspect of it. And I suppose finally I'd say, it's very common, it's stressful to be discriminated against. You know, it's a very unpleasant experience, and often it's happened, it goes on over a long period of time. And so your health, I mean, a lot of my clients have health issues as a result, you know, anxiety related mental health issues. And that's relevant. And I'll come on to talk a bit more why, but just in terms of evidence, you know, do go and see your doctor, get a record that that's how you're feeling, because it's relevant to the impact of the discrimination on you. But also, you know, sometimes you can develop some avoidant tendencies. If you've got a manager who's discriminating against you persistently, that can affect naturally how you interact with them. And having that sort of evidential paper trail to show any deterioration in your health may be relevant to defend any criticisms of you about that. So that's the other thing I'd say. I mean, that's and just before I forget, I must say, you need to keep in mind, your employer's policies on confidentiality, GDPR, don't just be forwarding emails to your
Very
personal
important.
email address. That's important. But, you know, we have a mutual friend who used to call it her sunny days file. You know, have a file in your Outlook. It doesn't matter. You just drag and drop. You don't take it out of your employer's organization though.
Yes, very important. Both because, you know, you've signed up to these, and secondly, because it might hurt you and your case, I suppose. Just on the mental health note, I think, you know, it's one of the reasons I wanted to have this conversation is because I work with a lot of female leaders who've had experiences over the course of their careers, and they often haven't done anything about it. And the effects that it has on their confidence, even years or decades later, are just profound. And it's such a shame.
That's why it's really nice to be doing this with you, Cecilia, because, you know, obviously I'm a lawyer and people come to me for a legal resolution, but undoubtedly just the act of asserting yourself has such a positive impact on someone's mental health. Obviously they're not coming to me for that sort of support, but that's the sort of support you can give more than me. But you're right, asserting yourself and not taking these things lying down is important from that perspective, because you carry it with you.
Yeah, you really do. So I'm going to go off script for a second and ask you something, because I just thought about it. What would you say to the people who might argue that we are creating unnecessary conflict and, you know, encouraging people to start wars against their employers when they didn't have to, and all this whole Me Too thing has gone out of control? I read somewhere that 3 out of 5 people in the UK now think that women's equality efforts have gone too far. And if you look at the statistics, obviously we both know that that is very, very far from the truth. But
probably not mainly women.
No. Well, actually,
so
a lot of women in those scores. Quite scary. Quite scary statistics.
I mean, I would say that, you know, I spoke at the outset about, you know, there used to be this sort of put up and shut up culture. And I think there is a move away from that, not fast enough, but slowly. And the challenge that comes from that is knowing how to raise these sorts of issues in a way that can, first of all, acknowledges that discrimination is a serious allegation. It's not, I mean, you can imagine being on the receiving end of that. It's not going to be pleasant. But also, you know, there didn't used to be the understanding that there is now about unconscious bias. So I think there is a way to raise these sorts of concerns without going so on the attack as you used to. First of all, because, you know, HR departments should be more open to dealing with these grievances in a responsible way, rather than just ignoring and brushing under the carpet. But also because, you know, you should be able to raise these points and fact find without making aggressive allegations and feel like you're banging your head against the wall. You know, the point is for both parties to engage to find a resolution. So I think it's got to work both ways. I think one of the reasons that it's been seen to be relationship destroying and aggressive to raise these sorts of claims is because people have had such a closed mind to them. I think as people become more open-minded to engage in the discussion and come up with solutions which aren't so much about blame as resolution, I think that should take some of the heat. I mean, there's no doubt they're serious allegations. But I mean, it won't surprise you to know that I don't think the solution to that is just to sort of sit back and put up with it.
Oh, definitely not. I'm about to swear. That's how strongly I feel about it. No, definitely. And so help us think about, I guess there are 2 parts to this question. The first one is, how does one raise this with, you know, one's employer in the most constructive way? And then I guess the second part is, if I'm on the employer side, any advice on how to receive it?
So in terms of how to raise it, I mean, most employers will have a grievance process, which usually says, you know, raise it informally with your manager in the first instance. And I'd support that. If you look at it as a sort of fact-finding mission, like we said at the outset, you don't always know that you're being discriminated against. And I don't think there's a problem with, I mean, at least yourself acknowledging that and using the grievance process as a fact-finding mission, but also to collate the evidence that you need. So the first thing might be, in a very informal, non-confrontational way, to ask your manager or the decision maker why they've made the decision that they have.
Yeah.
You know, and get that in writing, get some more information about that. And then that can inform your thought process. You know, we went through the different types of discrimination. Is there less favorable treatment? What's the reason? You know, getting that information will help you break that down. If you get to the point where, you know, having done that, you think, I think there is something here and I'm not really getting anywhere informally, then you raise a formal grievance. And so I guess that sort of shifts on to how your employer should deal with it. You know, so before I go on to that, I suppose how you raise the grievance is important.
Yeah.
So, you know, ideally, I think you'd have someone like me draft it so that it's, you know, clearly set out, it ticks the legal boxes. But also, irrespective of that, I think it's important to strike the right tone. So not to be overly aggressive, take a sort of inquisitorial approach to it. And that's sort of entering into the spirit of the grievance. I mean, you can't help it. If an employer is going to just sort of stonewall you and not deal with it properly, there's not much you can do about that.
Sure.
But you can see that that might have an impact on how they address it with you. And I should say, when I said, you know, someone like me should help draft it, that's often something we would do behind the scenes.
Yeah.
So we'd help you draft it, but you in your name, and you would send it. So it's not sort of overly aggressive.
I think we should talk about, I was going to ask you, like, at what point should people contact someone like you and how does that work? But why don't we, let's wrap up this bit and then I'll back to it.
So yeah, the only case where I would sort of go on the record sooner would be if someone is ill and is finding it overwhelming. Because sometimes getting emails and contact from the employer on the topic can be quite triggering. So in those circumstances, absolutely, I go on the record, but you can see there's a context for that not being so much about being aggressive as safeguarding. And then as an employer dealing with it, I mean, it's challenging, isn't it? Because like I say, I mean, you've also worked in HR, Cecilie, so I'm sure you've got some pointers on this too. But you know, I guess you need to make sure that you're investigating properly. You're not predetermining. You're in a difficult position because you're, you know, essentially answer to the business, and it may be that it's someone very senior that's being criticised. But essentially, I mean, what you should do is that the ACAS Code of Practice is there to set out the sort of the basic process you must follow. But I think the most challenging thing is about ensuring people aren't victimised. Once a allegation of discrimination has been raised, let's assume the person is still working with the person against whom it's been raised. I think it's human nature when you've received an allegation like that to be defensive. And the reality is that, you know, any sort of less favourable treatment because someone has raised a grievance is unlawful victimisation, and it's really, really hard to manage that in the workplace. I don't know if you have any insights. I know that you've dealt with sort of very senior, you know, board members being criticised in this way. I mean, it must be extremely difficult to manage.
I think it is very difficult to manage. And I think what happens is both for the person raising it and the person receiving it is that you know, the likelihood that both parties are triggered into some kind of fight or flight response is extremely high, right? Because what happens is the middle brain is going to perceive a threat to your safety and survival. It's like rejection, abandonment, humiliation, all of those, you know, really chunky pieces. And when that happens, it diminishes the access to our prefrontal cortex. And so that logical side, I should behave like this, I should receive it like this, it goes out the window and we go into a very emotional state. And so I think my advice would be, you know, get support early on, whether it's a you or me or a combination, or make sure you have space to reflect on, you know, a safe space to reflect on how you're going to handle this and how you're going to behave so that you can show up as the best version of yourself in a very, very challenging situation, because all of your natural defenses are going to kick in. That comes with kind of an adrenaline response and changes to your the neural functioning of your brain. You'd be able to see that on an MRI. I do a lot of neuroscience and nervous system regulation as part of my work, because we kind of dismiss that, but it affects us greatly.
Yeah.
So
But this is why they say lawyers should never act for themselves, even, because you just can't. You can't separate yourself from those sorts of physiological reactions. Absolutely.
And then I'd say go very slow, right? And make sure, like, step away, take breaks. I think that goes for any kind of conflict. You know, once you're in it, what do they say? You can argue for 20 minutes and then you have to take a 15-minute break because you get so caught up. And I think pushing through when you're feeling that that tension or that fear is a very bad idea. So, you know, go slow, get proper support, get proper advice. I
think the other thing is sort of know what you want to get out of it. It very much depends on what the issue is, and this is another reason to try and raise issues at an early stage rather than letting, I mean, it's very common to just let things, because you hope it's not going to happen again, or you're in denial, and often by the time you're raising a grievance, the relationship's deteriorated to the extent that it's very hard to rebuild it. Whereas if you're raising points at an earlier stage, there may be a resolution that actually the employer can accommodate quite easily. But certainly 100%. Knowing the outcome you want is, you know, if you can ask for that, they're more likely to be able to accommodate it.
Yeah, it's I'm thinking about the 4 responses that we go to when we get triggered, which is fight, flight. Those are the well-known ones. And then there's freeze and fawn. So fight is obviously picking a fight and going in too aggressively. Flight is avoiding, right? I'm just going to run away from the problem. Right. Freeze is being paralyzed and not doing anything because you're just frozen. And fawn is trying to people please your way out of it. So being sort of just extra super nice to everybody so that they like you and you're safe. And all of those are going to lead to a worse outcome, right? That's what you're saying. Like, effectively, you need to somehow get past all of that so that you can logically and early address the thing in a calm way.
Yeah, it's understandably really daunting. To raise these sorts of concerns. And one of the reasons, I mean, you've sort of explained really nicely sort of your angle on this, and one of the reasons for me also, I mean, apart from the fact that I try to avoid litigation for clients, but inevitably it happens. And, it's always, so it makes my life so much easier, and therefore my client's life, if they've got all this evidence together and we were able to, at a really early stage, articulate things properly rather than launching into a grievance without having the evidence. So then, you get towards the end of the grievance process and then the employer comes up with evidence that's contrary to what you've said, and you think, God, if we'd known that, we'd have put it slightly differently. And even worse, when you're in the tribunal doing that and you don't see any of this evidence until disclosure, by which point you've already issued your claim, you're so far down the road. So addressing all of this at an early stage is something which we, historically, I don't think individuals have really done, or sort of conducted their working relationships with this in mind. But, particularly with COVID, there are such delays in the tribunal now because of that. Even more so reason to try and deal with this, ideally when you're in employment, because, when you're in employment, you're still essentially your employer's problem. There's still this really high risk that they're going to victimize you, which, I know that it's not pleasant, obviously it's not pleasant to be victimized, but it really does strengthen your legal position. Often it's easier to prove that than the underlying discrimination itself, because you'll see quite a marked change in behavior. And so trying to encourage people to really think about these points at an early stage and take advice at an early stage so that we can get you a resolution whilst you're in employment, even if that's a severance, is so important now, because otherwise, if you're terminated or you resign and think, well, I'll issue a tribunal claim, I mean, that's still, it's still a recourse that you have, but you're looking at waiting a long time before you even get your case heard. And I think employers know this, so things have changed there. So
probably years now, right?
It can be. I mean, It was that if I give an overview of what happens at the tribunal, so you issue your claim, and then the employer has 28 days within which to respond to it from when they get sent it by the tribunal, which can take a while. Then there'll be a preliminary hearing where they set down orders, and it used to be that would be a month or so after the employer responded. At its worst, it was sort of a year after with COVID, and that's just to set down the directions, which are then disclosure, bundles, witness statements, and then a hearing. So recently we've seen that first preliminary hearing being 3 or 4 months after. So it seems to be getting better, but it varies largely between tribunals. But absolutely, it's not an easy or fast solution to litigate.
So when's the time to call you? Is it possible to do it too soon, or is it just a matter of actually pick up the phone as soon as you have that first instinct?
Well, I mean, I'm always very happy to have, well, in all cases, I'll have a sort of initial chat with clients just to get a feel for what the issues are. So in that sense, you know, there's no harm in picking up the phone to me. And then, you know, of course, there's a cost associated with instructing a lawyer. And so it's a personal decision for everyone at what point you want to incur those costs. But I mean, ideally, yes, as soon as possible, so that I can help you work through these points that we've discussed. But particularly, I would say if you're going to raise a grievance, come and speak to me first, because I'll help you do it in the right way. And it sort of sets the tone. That's what, you know, the whole process and your claims will hang off, and it will make a material difference to, you know, your employer's engagement with the issue, and therefore how likely you are to get the resolution that you need. And also, you know, I'll be honest, if I think there isn't, you know, that's not a discrimination claim, or I'll give you an example of something that a lot of people think is discrimination that isn't. Is if there's a relationship in the office, let's say stereotypically you've got a male boss and a junior woman, they have a relationship, they split up, and then she's sacked. You think that must be discrimination, but it isn't, because you're looking at the comparator would be, well, if it was a homosexual relationship, then a man in that context would be treated the same way. I mean, that's quite specific to that, but you know, it may be that often I can help say that's not how you should put it, you need to put it a different way. And you can see that if you just launch into a grievance and put it the wrong way, it's very hard to backtrack from that. So I would say certainly before you get to that stage of formally raising a grievance, and hopefully some of the pointers from today, like, you know, asking your manager, you know, ask questions, do it in writing, doesn't have to be overly formal, but if you can approach these issues with that in mind, then, you know, that's a long way down the process you can go to help yourself without taking advice. And then when you do come to take advice, you'll get the most out of it.
Sounds like it might also save you money trying to fix it later, actually spending a little bit up front. What do you make of this? I think a lot of people feel like if they do this, if they raise any kind of claim or grievance, that will be the end of the relationship, because they will be punished and penalized, and they will eventually lose their jobs. And so it's better to just go quietly and find a new job. And, you know, I think that's the storyline for a long time. What do you think about that?
I think that you know, like I said, I think times are changing a bit on that. I think we are moving away from this put up and shut up culture. That said, there's no doubt that it's still not, you know, you're still not welcomed with a bunch of flowers if you raise these sorts of concerns. What I'd say is, if you are anyway going to just resign, why not raise it? What have you got to lose? I mean, obviously there are, you know, relationships are important, but like I said, there are ways to do it which are appropriate. And you know, doing it in the right way, I truly believe that you can resolve a lot of issues. I mean, if I'm honest, it's not usual to have employers uphold grievances, but I mean, I have had it happen, and I know it's because of the way in which these issues have been raised. So yeah, I would say I would really discourage people from just putting up with poor behavior. I think that, you know, if it's really that bad, do you want to stay working for an organisation like that? It's unlikely to resolve. It's probably going to get worse. It'll have an impact on your health, you know, and if you're going to leave anyway in that context, why not raise it for the reasons we spoke about, also just to restore your confidence and stand up for yourself.
Amazing,
and
the
you know,
impact
if an employer does retaliate, then there are legal protections for you. So we spoke about victimization. If they don't go through the proper process, if they don't follow the ACAS code, then ultimately there can be an uplift of up to 25% on any award you receive, which is, you know, depending on your income, not an insubstantial amount. And also, if your health is affected, I would say actually, if your health is affected, that's a really good reason to come and see me sooner. Also, because if you meet the definition of disabled under the Equality Act, which it's a legal definition, not a medical one, and no one naturally wants to be associated with some mental health disability, but it's a low bar. There are protections for you as well. So an employer must make reasonable adjustments to any process, so you can make sure that it's dealt with in a way that you know, doesn't further impact on your health, which is relevant if you're raising, because it's stressful anyway. And also there's protection against discrimination arising from disability, which again, I touched on it before, but if your performance is being criticised as a defence to your allegations for reasons which may have been impacted because of your health, for example, avoidant behaviours or what have you, that's all relevant. It's a complex area of law, but I can really help with that sort of thing.
That's what you do, right?
That's what I do.
Amazing. Okay. Anything I should have asked you that I didn't? Any final thoughts, comments, pieces?
Well, yeah, I think one thing I do want to touch on, just to again help people sort of think this through for themselves, is how you get an effective settlement. Because ultimately that's what you want to achieve. And there are sort of three main factors which an employer will think about when entering into a settlement. The first is, what are the merits of these claims? And so you can see that if you've provided evidence to support them, then their minds will be focused on that. The second is, what's the value? So claims for discrimination are valued mostly based on what your likely loss of income is going to be, subject to you taking steps to mitigate your loss. So you can't just sort of sit back and put your feet up and say, I've taken 2 years off, give me 2 years pay. But, you know, particularly in, you know, I was going to say the current climate, but I mean, it's been this way for a while. You know, the market's difficult and it can take people quite a long time to get another role, particularly at a senior level where their sorts of roles just don't come available very often. And also, if their health has been affected, that can have an impact on how quickly they can get another job. So it's important to think about that. And in that context, think, you know, what could I live with? Because no one's got a crystal ball. You don't know how long it's going to take you, but you know, what would be a realistic compromise for me? What would I accept? It's important to think that through. And that's the sort of assessment that an employer will make, and you'll have to make arguments about that. There is, for discrimination, also awards for injury to feelings, but the most of it is about your financial losses. And they can be significant. It's uncapped. So if you've got a role, you know, you've got your salary, but also, you know, really valuable bonus or shares, you look at the loss of those as well. It covers quite a lot. So it can really add up. And the last, well, not the last point, but another important point is, how likely does your employer think it is that you're going to bring this claim? So there are time limits in the tribunal. You need to assert your claim via ACAS within 3 months of the act that you're complaining of. That's quite a short period of time.
That is a very short period of time, yeah.
You can look back, if you have a series of connected acts, let's say you've got one decision maker and each year you get less of a pay rise, or each year you get passed over for promotion. Technically, those decisions in earlier years would be out of time. Again, it's very fact specific, so don't take this as written, but there may be an argument to sort of link all of those together, so you can bring a claim for all of them with the time limit running from the most recent claim. But in any event, it will be relevant background to the latest decision. So it's not uncommon for employers to just think, well, I'm going to sweat them out. They're only 3 months. If they haven't brought the claim, that's it. We don't have to do anything. So one thing that's really worth looking at is you can get legal expenses insurance cover. Often it's included under your buildings and contents insurance. Bizarrely, it can just automatically be included, or you can ask for it as an add-on. It's not a perfect tool because it's complicated, but it can make a real difference. You can get cover for 100, 200, whatever it is. And so I would always, if you have it, tell your employer at the point of any negotiation that you have it, because it makes them realise that you're on a much more level playing field financially to issue this claim. And if you don't have it and you're watching this, I'd recommend getting it or checking if you have it. I think that was everything. I think that was the important point on settlements, but I think that's everything I wanted to cover. Okay,
so I just thought of one more thing, which is I get the impression that a lot of people are worried that if they take action in any kind of way, they won't be able to find another job, because especially in industries, say you're a woman, you've been discriminated against, it's one of these kind of boys club industries, that they just won't be able to find work because their reputation will have been ruined. And that's a very real concern for people, I think.
Yeah.
What would you say about that?
Well, again, this is a reason to focus on trying to deal with these things in employment at an early stage. The sooner you do that, you can hopefully come to a resolution that's private. In the tribunal, any judgment is public. I mean, it's not in the national press, but there is a database where there's a list of judgments. So I would say, I have to say, I've never had an individual come to me and say, because I had this judgment, I've not been able to get another job.
Well, that's good to know, right?
But I understand the concern. There's not much you can do about the fact that tribunal processes are public, but they're public also for the employer, and that's one of the reasons often that the employers want to settle. I mean, apart from the commercial aspect of it, but I would say, there's lots of reasons that people can be fearful of raising these issues because of the culture that we live in and where we've come from. The point is, things are starting to change. I think that the law really helps in this area. I think it really does show a roadmap for how to raise these things in a responsible way. There's no doubt that it's challenging, but I mean, what I hope to do is support people to do it in the right way that will encourage their employer to engage and to get them a resolution at a really early stage.
Fantastic. Thank you so much for all of that.
Pleasure.
Sure, that will be very helpful to a lot of people who might be thinking about this topic, or work in functions where they, like I used to, have to think about this topic, because I think there's a lot on the employer side that also needs to change and can be done in a much kinder, more open way that actually would make the problem go away, right?
Yeah.
At an earlier stage. So thank you so much for that. Guess that's it, isn't it?
Yeah. If anyone's got any concerns, just pick up the phone to me. I think.
How do we get in touch with you, Emma?
Yeah. Well, I'm on the Edwin Coe website. I think you can link to that. But very happy to chat through any issues. 20 minutes or whatever, just to see if I can help and give you a bit of guidance.
So keep a file. Talk to Emma. Don't
put things in writing.
Answer it too aggressively. Yeah. Cool. Well, thank you.
Thanks, Cecilia.